Well, thank you. That was that wasn't Shakespeare in 1 hour. That was a masterpiece of distillation. So that brought things together in a way that I think really shows a logical development and so on. So thank you. I want to say I'm going to be a little bit critical of Dobbs, and so I want to start off by saying that of course I think it's a great victory, both for the conservative legal movement, that is to say those simply concerned with the court's overreach, and for those who are simply concerned about protecting unborn children. In both cases, I think it's a great victory. And I think indeed it will be surely a landmark case, however it ultimately fares, and one of the most important decisions the Supreme Court has ever handed down, since it has implications far beyond abortion for how the Supreme Court will treat various social and other kinds of issues for the foreseeable future. If only Obergefell, the same-sex marriage case, had come up this year instead of 2015. For those of you who may not have read Dobbs, the decision yet, I would strongly encourage you to do so. I think, and I would concur with Professor Kirk, that it really is a masterful exposition, far superior in its reasoning, in the quality of the reasoning and of the argument to either Roe or Casey. And it's overall a model of lucidity, dispelling Roe's meager legal rationality and estranged relationship with historical truth. And like many others, I thought that if Roe was ever overturned, it would be only gradually by being nibbled away at, rather than a complete overturning as we had, because of the court's normal fear of severe social backlash, which in fact happened after the case and after the infamous leak of the draft last spring. I used to tell my students that, of course, we should all of us go on an extended champagne-drenched celebration, such as we see in locker rooms after major sports championships, if Roe were ever overturned. Well, now that the hangover has worn off and we've all washed the champagne out of our hair, it's time to look in the sober light of mourning at what Dobbs really means, its positives and, dare I say, negatives. So I'll be gently critical in a couple of places. My goal this morning is to speak to Dobbs's claimed neutrality that is most starkly stated in Justice Kavanaugh's concurring opinion. But it's also really, I think, is at the heart of, is sort of the result of Alito's opinion for the court as well. Before I can speak directly about Dobbs, however, I'd like to say a few things about what I think is wrong with Roe, or was wrong with Roe, beyond the obvious injustice of killing unborn children. And I don't mean to overshadow that, I just want to broaden the context. To give a sense of the scope of the problem Roe presented, and in many ways will continue to present. Roe was part of a long line of cases, as Professor Kirk has pointed out, and not all of these were concerned with the precise issue of abortion and life, but they shared some broad assumptions about the jurisprudential and the human or anthropological aspects of society and how we live. Not only, in other words, assumptions about the role of the courts and the nature of judicial review, but also assumptions about what constitutes a human person, what human nature is, what makes life worthwhile, and so forth. And that, kind of comes out in the Casey decision when, in the so-called sweet mystery of life passage. First, more broadly, the court had effectively made itself the guardian and promoter of the sexual revolution, and Roe was clearly central to that endeavor. It enshrined the concept of decisional privacy, which was then transmorgified into a simple liberty claim in Casey's famous, and most exemplified in the famous or infamous sweet mystery of life passage. Elizabeth Anscombe said in the earlier context of the growing spread of contraception, that contraception's widespread acceptance would make it difficult for us to say why sex should be confined to marriage, or even why there should be marriage, or why homosexual relationships or intimacy should be disapproved. Hers, I guess, was a more innocent time, but in any case, here we are. If the sexual revolution elevates the pleasures of sex abstracted from children, marriage, and families to a central feature of its idea of the happy life, and if a certain culturally dominant form of feminism thinks that women, to be equal to men, must be essentially just like men, then contraception and abortion must be guaranteed. So in other words, not only then do we have a falsified understanding of masculinity, and not only are men falsely masculinized, but women are falsely masculinized too, I guess you could say. Many have pointed out that Roe understood the person as essentially an interest-bearing chooser before it, the person, could be anything else. I say it, advisedly, in scare quotes, of course. It based personhood on independence or separateness, as the Solicitor General put it at the oral argument for Dobbs. Indeed, this is presumably the very basis of the so-called viability standard, as the Solicitor General in Dobbs had emphasized in oral argument. Again, as many have pointed out, it therefore pitted the mother's and child's interests against each other. It understood the person as forming relationships and communities as acts of individual will, and therefore is essentially contractual in form. Since the unborn cannot do this, their full human status is put into question. But Roe also effectuated a separation between law and nature, understood in any fully adequate sense, that is to say, in any fully human and concrete sense. It did this by understanding the person in abstraction from his or her always already given membership in an organic tissue of relationships. Let me talk about this last point. Above all else, the man-woman and parent-child relationships defy Roe's view of the person, for they are organic and given. They're organic relationships and communities because they cannot be without the whole. There can be no parent-child relationship without the man-woman relationship, just as in truth there cannot be the man-woman relationships without the possibility of the ordination toward the parent-child relationship. More fundamentally, there can be no men but for the reality of women, and there can be no women but for the reality of men. They are correlative realities that point to each other and indeed constitute each other, and yet profoundly order, indeed partly constitute who each of us is. This means that each of us is who he or she is in part because of the organic givenness of these two possibilities of male and female. Analogously, there cannot be children without parents, nor parents without children. Like the man-woman relationship, each implies the other. The child is made for the mother's breast as the breast is made for the child. When the father looks into the eyes of the child, he sees his wife or himself or his parents or some mixture of all of those. This is a fundamental human experience, putting us in touch with all that we owe those around us and indeed with our own mortality. It is a fundamental experience of human existence. It places us within the vast river of the generations in time. And it's given because no one can give him or herself his or her sex, despite the attempts to do so in our current trans sexual economy. And while we may choose our spouses, we do not choose the ordination we bear towards our spouses. And therefore, spouses' acts of freedom are internally ordered. It is not just pure, abstract, formless choice. No one chooses to be a child or even to be someone's child. And even though the parents exercise freedom in having children, they do not give themselves the ordination and capacity for having them. And therefore, once again, their act of freedom is internally ordered. It is not just pure, abstract, formless choice. It is more concretely their participation in the realization of their destiny together as husband and wife. So these relationships and the resultant communities are organic and given, and they help to define the essentially human. Nothing less is at stake in the debate over a whole host of issues concerning abortion, the ascendancy of gay marriage and gay rights more generally. In other words, rights that would be based on being gay as opposed to simply being human. And categories such as gender or gender identity and so on. These concepts, such as the concepts of sexual orientation or gender identity, are in fact category mistakes, untruths, and even lies masquerading as primary paradigms, sorting out and conceiving the nature of sex universally. They are only a way of diverting our attention from the essentially human. In fact, they are a way of covering over the essentially human. And they cannot even come close to pointing out the profound depth of the meaning of our lives because they point exactly in the wrong direction. Okay, so Rowe embodied the rejection of this organic givenness of the human person. Rowe tells us that the child, if we were to allow its actual existence as a child, would be a possessor of rights and interests in competition with those of the mother. Therefore, we cannot admit to the unborn child's having the dignity of being such a possessor. In this way, Rowe denies the organic relationship of mother and child. The relationship is founded instead on a choice, an act of will of the mother. It also conceives of the pregnant woman as a solitary bearer of rights and interests in relation to the wider community. The child's father is explicitly placed outside the relationship of the mother and the child. Having broken all organic and given relationships, Rowe paradoxically also exposes the mother to the external pressures from other interest bearers, including that of the father, who may well be pushing for an abortion. More remotely, but also in an even more sinister way, it suggests that an entire economy and a set of social conditions that militate toward an abortion-fixated society, a purely chosen and then often unchosen relationships and projects. This is all made very explicit in Casey and was recently reiterated by Secretary of the Treasury Janet Yellen when she framed the abortion debate as concerning the best or most rational choices for pure economic actors. Importantly, Rowe's assault on life had vast implications for life in other areas as well. If unborn life is not to be considered fully human and personal, then it makes sense that the unborn could be exploited for purposes of experimentation, testing, and as a resource for the production of vaccines or other pharmaceuticals, cosmetics, and food products, and so forth. Consider how much harder it is, for example, to say why it is wrong to procure and exploit embryonic stem cells when Rowe has made the idea that embryos are merely potential life the law of the land. At the same time, if the unborn child is not really yet a child, then I can manipulate it for the sake of having a child when I decide I want one. And if the process makes excess embryos, which are ultimately culled, discarded, or indefinitely frozen, that is not a problem either, for all the same reasons. If Rowe denies the organicity and givenness of human nature, of relationships and human communities, if it conceives the person as most fundamentally a chooser and possessor of interests, which are in necessary competition with everyone else, or if, like Yellen, the person is reduced for policy purposes to a purely rational actor of economic analysis, then others who arguably cannot choose and have at least diminished interests or reasons reason may also be no longer count as fully human. So the seriously ill, the disabled, and the aged. So Rowe also had even more fundamental effects on the way we think and speak of ourselves and of our communities. It distorted language and therefore thought. I have been using the phrase unborn child, for example. Of course, the phrase is widely considered tendentious and loaded because Rowe has negated that way of speaking as a legitimate part of public discourse. It has thereby made the biblical phrase being with child not just quaint, but nonsensical. In this way, Rowe not only effectuated the twofold injustice of tens of millions of aborted children, it also changed the way we are permitted to think about ourselves and the things of our world. It entails an entire worldview from which none of us can entirely withdraw ourselves. It is not simply the passing of a phrase in the wake of a changing society. it is the loss of a world. Cardinal Ratzinger famously said that the unborn child is a model for all of us because it is the unborn child's radical dependency that characterizes the very human condition. The unborn child makes very explicit our relationship with God and those around us. Ratzinger could only say this because he understands human communities as organic and given. For all these reasons, the denial of the unborn child's humanity was always a substantial denial of our own humanity. Defenders of Roe, such as Justices Sotomayor, the late Justice John Paul Stevens, or the legal philosopher Ronald Dworkin, have argued that Roe's detractors proclaimed that Roe's detractors' declaration that personhood or the full humanity of the child begins with conception must be dismissed as necessarily relying on theology or religion, since only religion, they charged, could make this judgment. Hence, such a position could never be enshrined in law within a legal regime that strictly separates church and state. Far from me to say that we can know the origins of life or its beginnings without ultimately seeing them in God. Yet these thinkers seem insensible to the fact that their own positions prove too much, for they are themselves far more theologically committed than they would want to admit, since if deciding about the beginning of life is necessarily theological, Roe does, after all, decide when life begins. It proclaims that life begins at live birth. For every moment preceding this event, the entity at hand was only potential life, according to Roe. Why precisely is the judgment that life begins at conception theological, while the court-enforced judgment that it begins at live birth is not? Now, what about Dobbs? How does Dobbs change or not these implications? Clearly, Dobbs opens a path to recognizing the humanity of the unborn through positive legislation at the state level and perhaps at the federal level too. This is a start, and for this reason it can and should be celebrated far and wide as a great victory, as I said. However, let's consider this from the standpoint of Roe's implications for the human person. Like Roe, Dobbs continues to project a conception of the person as merely a possessor of interest and rights. This frame of mind is most visible in the way the court decides Roe's and Case's viability standard is not only ahistorical, but also arbitrary. Justice Alito reasons that the mother's interest in receiving an abortion after viability is just as great as her interest just before, and the unborn life's interest is just the same before as after. This form of argument has at its center the figure independent or separate individual possessors of rights and interess. That was the hallmark of Roe and Casey, which was highlighted by the Solicitor General during oral argument. It suggests that state legislatures' consideration of the issue should involve some rational, in other words, non-arbitrary means of mediating competing rights or competing interests. Now, Alito's larger point is that for liability or some other boundary to be non-arbitrary, it would have to be intrinsic to the nature or development of unborn life, rather than owed to external and variable factors, such as the capacities or availability of medical or technological intervention. And this search for a principle intrinsic to unborn life is, in itself, it seems to me, a very positive development from Roe and Casey, which refused even to think about the humanity of the unborn child. So there is a kind of openness, I think, here that has to be acknowledged and thought about and hopefully exploited. The unavoidable implication remains, however, just based on that language, that were such a bright, non-arbitrary line available at some point in utero, it would be because at that moment in development, the fetus or embryo went from incapable to capable of possessing interests. Even more grotesquely, it also treats the mother's interests as in tension with the child's. That Roe had, in fact, already effectively determined that the unborn child does not possess present interests, only calls our attention to the fact that Dobbs assumes the opposite, that the unborn might indeed, or perhaps does have such interests. Yet for all that, the potential possession of interest remains the assumed basis for non-arbitrary line drawing. And so here, as in Roe, the center of the human seems to be the individual bearer of interests. But there is there's a more fundamental way that Dobbs continues Roe's false anthropology. Importantly, as Professor Kirk emphasized, Dobbs does not require states, Roe did not require, nor does Dobbs require states to protect unborn children. Rather, as has been indicated, Dobbs holds that the Constitution says nothing about abortion, and therefore, for an abortion right to be constitutionally protected, the right would have to be part of our history and tradition and ordered liberty and those things that Professor Kirk outlined so well. So barring federal legislation, states are free to regulate abortion either restrictively or very liberally, or not at all. Emphasizing this constitutional neutrality regarding abortion, as I mentioned, is in fact the burden of Justice Kavanaugh's concurring opinion. But notice, in pursuing this supposed neutrality, the court has silently distinguished between the born and the unborn, between born life and unborn life. The court would clearly apply the protections of the 14th Amendment to an infant or a small child. So in effect, the court has decided that the unborn child is not similarly situated to the born child. If the court would immediately treat the small if the court would immediately treat the small child or the baby as a person for constitutional purposes, Dobbs does not extend this treatment to the unborn child. Therefore, the unborn child, unlike the born child, cannot receive the constitutional protections accorded to the latter. The rejection of constitutional personhood holds throughout pregnancy, even right up to the final days of a 9-month pregnancy. Otherwise, jurisdictions like California or New York could not even contemplate laws that extend abortion to the last moments of pregnancy, or truth be told, perhaps even a little bit beyond. Now, we do not have here a clear theoretical reason as to why the unborn child should not be considered a person, or on what basis the line should be drawn between the child who is almost ready to be born and the child who has just been born. Gerard Bradley of Notre Dame has pointed out that this line drawing seems just as arbitrary as Roe's viability rule. But inevitably, we are again left with the impression that the basis for the discrimination is the unborn child's lack of independence or separateness from the mother. Dobbs therefore effectively reinforces the implied rejection of the organic and given nature of personhood. Indeed, insofar as the division between born and unborn is thought not to be simply arbitrary or a purely positive determination of law, it must be based on an assumption about the nature of human personality. The court, perhaps without realizing it, then assumes the full humanity of the child is rooted in separateness. But if so, then the presupposed conception of human nature is one that is precisely the antithesis of the organic and given sense I outlined earlier and presupposed by Ratzinger in his statement. On the other hand, if it really is just a matter of an arbitrary and purely positive determination of law, then we're faced with a radical separation of law from nature, or even from reality, and we find ourselves back in the domain of arbitrariness. Consider another side of this same point. Notice that Dobbs's conclusion that the Constitution is neutral toward abortion amounts to a declaration that the question of the full humanity or not of the unborn child is a matter to be decided by democratic process, in the same manner as, say, tax policy or public works initiatives. It means that one's response to a state's denial of the humanity of the unborn child should be to try to convince 51% of the voting public to recognize the support that humanity, that recognize and support that humanity so that the state's abortion laws can be changed. It is to say, in other words, that the question of the full humanity of the unborn child is to be decided as a matter of policy. One problem with turning this over to the democratic process in this way is that it insinuates in citizens' minds, however subtly, that the question of the humanity of the unborn child is the sort of thing that ought to be voted about. But how can the question of humanity be a matter of policy? Is that really a matter that should be voted on? Shouldn't it rather be a matter of principle, rooted in the foundations of our legal culture, rather than as a legal outcome? How can the existence or non-existence, being or non-being of someone's full humanity ever be a matter of policy? Isn't the question one of nature? Isn't it similar to thinking that the question of whether men and women really do exist is a policy question? No, these are questions concerning what is real, and law needs to be founded on the real. Law is always a pedagogue. In limiting and guiding our activities, it forms us in our beliefs and interactions. Indeed, its very purpose includes, in large proportion, the pedagogical, especially in this social domain of persons and relations. If a legal regime is successful, it not only prevents people from killing each other, it also teaches them not to even want to kill each other. Were law not fundamentally pedagogical, and were it not for the fact that everyone knows that it is pedagogical, contending sides would not struggle so mightily to control law's symbolic content. Now, its pedagogy always refers back to, by implication, to some sort of meaning of things, or absolutes, or first principle concerning things in the real world. This is true, for better or worse, even or perhaps most especially when its practitioners, such as Justice Kavanaugh, claim it has no metaphysics by professing its neutrality. After all, after just a moment's reflection, we can see that Kavanaugh's statement that Dobbs' interpretation is neither pro-life nor pro-choice is false. Dobbs is thoroughly and completely pro-choice, indeed just as pro-choice as Roe. If Roe guaranteed the choice to the individual pregnant woman, Dobbs has simply shifted the choice away from the individual and onto the people and their representatives. Now, to turn over the status of the unborn child to the shifts and moods of the people and their representatives is certainly not to take a neutral stand, as Justice Kavanaugh proposes. Rather, it is to have already given, without reflection, perhaps, an opinion or a judgment about the unborn child, is to have decided something about the unborn child. Well, certainly, as I started off saying, all in all, the Dobbs decision presents a great victory and a good outcome, at least for now. And indeed, the best we could have hoped for, because let's face it, the constitutional personhood of the unborn child was probably just never in the cards. Given the certainty of the intense, sustained, and violent backlash, the necessary for creating, a five justice majority, and the violent backlash might very well have threatened the integrity of the court and therefore also the constitutional order. So I recognize very much is at stake here. And yet, as I've suggested, there's something dissatisfying about Dobbs. Consider for a moment the position of abortion supporters who are deeply offended by Dobbs. If you ask, why are they offended, the answer is surely a complex, but at least in part it is the following. Even though they are free to vote for abortion rights and will likely pass more aggressively pro-abortion laws in certain states, abortion supporters cannot stand the thought that in other states abortion may be severely regulated. There is something less than fully satisfying about having one's position inscribed only in the shifting sands of positive legislation. For better or worse, our modern liberal manner of sacralizing something is to enshrine it as a right beyond the vagaries of the democratic process. And abortion supporters certainly want their idea of rights and the nature of what it is to have a human dignity represented in the legal pantheon this way, as a sacral, unchangeable, and immovable thing, as a first principle, which it was under Roe until it wasn't. It is or should be the same for us. Unless our only concern really is for judicial restraint and promoting the original doctrine of interpretation, then our concern is not only for the right legal rationality or right jurisprudence, but to protect life and to arrive at a wholesome human culture in which, yes, life is sacred. So it's not a right, which is an abstraction, but life itself, the person, is sacred. And in that case, we cannot really be happy unless the basic law of the land is able to comprehend the full humanity of the unborn child, which means, as I said, comprehending our own full humanity. And that can only mean that we would put the question beyond the vagaries, of the democratic mood. Do I have a little bit more time? 5 minutes. Okay, I'll just talk really fast. So I want to raise, it was touched on by Professor Kirk, and I want to raise again, I've already pointed to what I think are places in this very well-written opinion, where I feel there's a certain tension. There's another basic sort of architectonic tension that I'm very interested in, that creates a certain ambiguity that I like. I like the ambiguity, actually. And that is, as Professor Kirk mentioned, the primary argument here is the originalist one, right? And I'll explain this rather than really go through my text for the sake of time. So, the court is saying, look, abortion is not in the Constitution, therefore, if it's going to be part of, substantive due process, then, it's got to be part of the history and tradition of rights, or it's got to be part of ordered liberty, and so on and so on. And it goes through very well and says, well, it's, none of those things. But then there's the problem that was pointed to already by Professor Kirk. The court doesn't want to say, well, this entire world of other cases is also, by the way, now overruled. And, so you've got everything from, Griswold, which, never uttered the word substantive due process, or I guess it did, but only to dismiss it. But then the dissent, a dissenting opinion there, or a concurring opinion, actually, well, all of them said, this is just substantive due process. And then, these other ones, these other cases, the way to distinguish is to say, well, abortion, after all, is about life. And I think the tension here is, the primary argument that is originalist is this sort of jurisprudential argument. And then suddenly, sort of deus ex machina style, you get this other principle that comes out of seemingly nowhere. Well, this one is different from those others because it's about life. And I find that really interesting, because you end up then with these two principles. It's not clear how you put them together, and it's lying sort of side by side. And so what I'm wondering is whether, it isn't a hint if the court has, shown its hand a little bit, and the ostensible neutrality is not really ostensible neutrality. I mean, and that this question of the life or the full humanity of that there's a kind of openness, right? That this principle has been sort of put in play, as it were, and maybe could have some kind of a life of its own. I mean, on the other side of it, of course, the distinction for people like me is disappointing, because I think all those other cases are very important as well, and not to just be distinguished and set aside. The court doesn't want to go there, and they would all involve, of course, their own difficulties. Like, for example, Obergefell, is going to involve, reliance issues. So that's a pretty hard wall to scale. So I'll just wrap up here. So Justice Kavanaugh claims that Dobbs brings us back to the status quo ante. But no man ever steps in the same river twice, Heraclitus observed. Prior to Roe, abortion regulation was undergoing changes, but it had not been declared a constitutional right. Because Roe made it a right, it raised the social stakes substantially. But Dobbs' necessary attempt to remedy the court's legacy of lawless overreach effectively removed what was thought by many to be a right for 5 decades. And it leaves in place, but it also, as I've tried to point out, leaves in place some undesirable assumptions, I think. Just as tragically, Roe catalyzed the almost religious zeal of abortion advocates. And so we are left with a riven social fabric and volatile political scene. And so Roe left us far worse off than we would have been, and Dobbs cannot really bring back the status quo ante in anything more than a purely formal sense. Thank you.